right, everybody. Welcome to this special presentation. And I wanted to put this together because I know there's a lot of people out there that are trying to figure out what's happening with this jury, why they are taking so long. And I think a lot of it's because I hear people out there, they say, I watched the trial, I watched every single day of the trial, and you might have. But when you were watching the trial, especially when you have a trial of this length, you're missing some things. You're missing some nuanced things that maybe the jury picked up on because they were there. Also, in the closing arguments, that the attorneys put it together for the jury, and the jury is now thinking about all these things that they saw. And remember, the jury sees these things one time. So when they're sitting in that courtroom and they're focused on this and they're not distracted by anything at home, they're not distracted by anything else other than sitting there and digesting these witnesses. And they see things that we don't sometimes, or maybe some of us see them, but others don't. So I want to go through and kind of demonstrate the, in my opinion, strong reasonable doubts that exist in this case. Um, by using the closing argument of the defense to highlight some of these things and show you why this jury is struggling with the case and why I think we could have a mistrial here where the jury never reaches a verdict. We could even have a not guilty verdict, or we could have some form of a mixed verdict here. And I'm going to show you also how this jury, if they're analyzing this, if they're paying attention and they're not being biased and they're approaching this from a perspective of the presumption of innocence, you're going to see how this jury could be seeing things much like the OJ jury did when they were sitting there for 9 months. And they saw things that the public missed because the public was biased. The public was um, extremely, they'd already decided what the verdict was going to be in their mind. And they weren't sitting there getting instructed every day by a judge telling them, keep an open mind, don't start deliberating. They're not able to talk to anyone. They're not able to discuss the case with anyone. And if they're doing this right, they're not formulating any opinions that's getting in the way of just looking at this case with a full 360-degree view. So I want to show you some of these things. Some of this you may have missed. Some of these things I've discussed before. But I'm going to take you back. We're going to go through. We're going to look at the different things here that are going on. So first, let's jump in here. So there you have it, the trail cam. Okay, the trail cam footage. We're going to take a look at this, and we're going to investigate this fully here. I'm going to show you some of the testimony you may have missed, but we're going to listen first. The way this is going to work, we're going to listen to the defense attorney tell us about the trail cam footage. Why is that significant? What might be on the jury's mind about that? First off, the trail cam footage is one of the things that stands out in as a suspicious activity from Scott, one of the two sons, the son who is the caretaker of the farm. And on the moments after his father's discovered, um, actually, it may have been moments before the father was discovered, he's walking up to the trail cam and he's deleting it. But it's being done, right as the father's body's being discovered on the burn pile. Actually, I think they were still searching for the father, and he's going up and he's deleting the trail cam footage. He doesn't tell anyone about doing this. He doesn't tell the investigators about doing this. They discover it, as you're going to hear in his testimony. They discover it because Scott doesn't realize that the trail cam footage is going to take some pictures. On top of that, they did retrieve, and I've heard some of you say, well, they retrieved all the photos. Well, you're going to hear the judge in his questioning of the expert. You're going to hear the judge lay out for the jury exactly how footage and photos could have been on that trail cam from the previous few days, showing what happened, showing what was going down, showing who was near the burn pile. and those photos could have been deleted. And that's because of the mishandling of the trail camera by the police, because they left the trail camera on. And the way this trail camera works is it will start to uh, go over. Basically, when something gets deleted, it's not actually deleted. That's why they were able to retrieve some of the photos. But as more photos are put onto the SD card, the metadata, which would allow for some of these deleted photos to be pulled up, starts to get deleted. It gets written over, so it can't be retrieved. And if that happens, then it eliminates those pictures from ever being able to be retrieved. And by the estimate of the judge, there was about 8 photos taken after it was put in the hands of the police. Not only on top of that, after Scott deleted the pictures, it started taking other pictures. Took pictures of Scott himself, of Melody, of the daughter, Amanda, who was there. So every time one of those pictures was taken after that, it was deleting the metadata, deleting the ability for these other pictures that were deleted to ever be retrieved. Meaning there is a large amount of pictures that could still be there. And then on top of that, there were photos not turned over to the defense. The defense got 16. There were 14 missing photos of what you're going to hear. That 30 were turned over. Now, this gentleman says, I saw them. There's nothing of substance on those photos. But again, why would they not be turned over to the defense? This is disturbing stuff. But this is also reasonable doubt. You have a trail camera that could have shed light on what happened, just like the searching of the barn. That never happens. And what do we have? But we have stuff being hidden from the defense. So let's take a look at this. Reasonable doubt, one of the big pieces of reasonable doubt, number one, the trail camera. Let's take a look and see what we have here.
Also, the trail camera. Scott admitted to deleting the trail cameras on July 5th during the middle of the search for Mr. Farris. You didn't hear any evidence of Scott telling law enforcement in any of his questioning in interviews or anything like that about deleting the trail camera. You just heard that from the stand while he was testifying. The SD card stuff. So, do you know who deleted the SD cards?
I do not.
Okay. Well, so you didn't delete them, right?
Correct.
Okay, because Scott Farris testified earlier that last week that he was the one who deleted it. So it is your opinion that, I know it's from the top, I believe. So this one, it says 1, it's got the file name and all that, and that's the photograph. So this is photograph 1, correct?
Yes.
Okay. So this is the last photograph that was deleted, correct?
Yes.
Because that says deleted is true, and that individual who was previously identified as Scott Farris is walking up to the camera, correct?
Yes.
Okay. Then you got another one that is not deleted, and that appears to be the same individual walking past the camera again.
Yes.
Okay. And then you've got just things on the 6th, and these are you weren't there, but those are Sheriff's Office investigators.
Yes.
Right? Okay. So, I want to go to your review of the Dell. What are these photos that you didn't turn back?
I mean, I had provided everything that I had out. There was photos from a couple months prior of more raccoons and more deer and what looked like some gardening.
No. Go ahead, Mr. Ray. What do you mean a couple of months before?
There were some images from, I believe it was March and April, that were just other animals and other things crossing in front of the cameras.
Okay, so what about June, a whole month before? You said March and April. May, June?
Not that I remember.
So there's a whole month that there's not even a squirrel on this farm in front of that deer figure?
Correct. And
Who told you what to turn over?
I turned over everything that I had.
But no, you didn't, because you're testifying that there were other things that you didn't turn over. Right? You just said it.
I mean, I provided the raw data from the devices itself and produced every report that I was asked to.
Who asked you to produce this report?
DA's office as part of discovery.
Did they tell you to limit the photographs that you turn over?
So this report itself was a report that was created by Mr. Castellano upon his initial work. I believe I said earlier that he had pulled the information from July.
Okay.
And put it into this report.
Okay. So is it your testimony now that you took those other images that you found that you claim have no evidentiary value? Did you turn those over to the DA's office?
Yes.
Okay. So they have those images.
I turned over the raw data from the SD card to the district attorney's office.
Okay. Did that raw data that you sent over, did it look like this or something similar like this?
No, this is a report that was completed and had information from the month of July as pulled from the camera.
Okay. Is there anything else that you have turned over that you haven't heard us talk about today or ask you about? Photographs or any other thing that was maybe relevant?
I mean, I've turned over all the digital files that I had to the district attorney's office.
Okay. So your testimony is you turned over those other photographs, correct?
I did not, the same way as I don't hand over each individual file to a computer. Mm-hmm. I turned over the files from the SD card.
So you're saying you turned over everything that was on that SD card?
A copy of the SD card was sent out.
Okay. And so if the copy of the SD card that I get only has 11 photographs, that's not correct, or I'm sorry,
I mean, I
16 photographs.
I don't know what you were provided, but if you were only provided something with 16 images, then
what you turned over was more than that.
It was a SD card, an image of the SD card. So it was a complete copy of the SD card.
Okay. How many photographs were on the SD card?
I don't know.
Not deleted, deleted otherwise. Just as best of your recollection.
I mean, complete guess, 30.
30. So if I told you I only had 16, that's half, right? Roughly.
Roughly.
Okay.
One more. You can't guarantee that there aren't images that aren't missing from the SD card of the trail camera that weren't deleted and overwritten while, we'll start over. There are multiple photographs of the trail camera continuing to take pictures after the event. No one turned it off.
It obviously was turned off at a certain point.
At some point after it took about 8 images on the scene and in your office.
I was about to say, the last picture was an individual in my office. I imagine that's when they were
So
turned
no
off.
one turned it off or just took the SD card out?
I do not know the answer to that one. But yes, it would have either been turned off or somebody took the SD card.
But not for some period of time.
Correct.
You can't guarantee that there aren't images that were deleted that weren't overwritten by the other photographs that continued to be taken by the camera.
Correct.
All right.
I recall.
But talk about the trail cameras. So that is 12/12/75/2018. That's Scott. He admitted that's him. Amanda also identified him. That is him walking up to the trail camera. Now, what you may be wondering is, how do we know that that's when the photographs were deleted? Well, we know that because there's essentially a way to print out the photograph to where you can get the data, call it metadata, call it whatever you want, of each of the photographs that were on the SD card. The two relevant ones, you see on the top one, Scott walking up, and it says deleted at the bottom, deleted true. That means that it was in fact deleted. So every photo before Scott is deleted. And then he's picked up on trail camera at 12:16 and it says deleted false. He's walking by covering his face. So he essentially deleted it and then got picked up walking by 4 minutes later. Now, what was his excuse for that? Well, just searching for my father. I think a gun's missing. I'm worried about his safety. Need to check the trail camera and, I just always delete photographs from the trail camera whenever I go and check it. In the middle of searching for your father.
All right, guys. So there you have it. Listen, let's break down some of what we saw there. A lot, right? And this, again, remember, this all happened in front of the jury. The judge let all of that unfold in front of the jury. Some of you may have missed a little bit of that. Some of you might not have seen that expert on the stand and, might have not even picked up at the time what it was we were looking at here. But listen, what the judge was pointing out to the jury and what the impact of that is basically he's saying, listen, Scott comes up, deletes this thing. The state's showing what they allege to be all the photos. There's missing photos. There's 14 missing photos that the defense never saw, that the state never turned over. In addition, there are 8 photos that were taken after the fact of investigators at the office. The camera was never turned off, so it was continuing to record over previous photos. And then there were the photos that were taken from I guess the 5th and into the 6th before it was ever taken off. So you're probably calculating that there could be anywhere from 8 to 10 to 12 photos that could have been on there. And then it was established that, guess what? They don't know the order that the metadata gets deleted. So whether it could be the last one, it could have been photos that were taken on the 4th and the 3rd that could have shown or demonstrated, as we're going to learn, there is nothing determined in this case, really, by any of the evidence. Everything is unknown. And this case, unfortunately, as frustrating as it is, when you look at the case, when you look at the investigative work done on this case, we've got a trail camera. We have no idea if there's other photos that are on there. We have a guy who's going up to delete this trail camera, as the defense attorney says, who says, yeah, in the middle of searching for my dad, I'm going to go delete photos off of something that could have shown. If Scott would be thinking to himself, my dad has been found on a burn pit. I want to find out who did this. Why would you go delete the trail camera when that could absolutely show who did this? If you're not responsible for it or had nothing to do with it, why would you delete it? It would be in your mind where you would be thinking to yourself, oh my God, I'm going to take the SD card out and have it ready for the police, not come up, look at it, and then just delete everything off of it. Even if you didn't see anything on it, you might say, well, you know what, I want to have this here just so that maybe I missed something on it. So this is highly suspicious behavior, and it's only going to get worse as we look at the evidence presented in this case when it comes to Scott and it comes to his role in this. And remember, those of you that want to say, okay, Melody, still would be, did this all on her own. Scott's this kid that has an alibi. He's accounted for. You're going to see that is not what the jury saw as we progress. Now, one of the things in this case is, when did Gary pass away? And what you're going to see here now, the next phase we're going to look at is the CPAP machine. The CPAP machine is what the state has used to say Gary wasn't alive on the 3rd. or past the 3rd, because according to the state and the data that came off of the CPAP machine, they're saying that that data says that Gary used the machine. The last time he used the machine was the 2nd into the 3rd. What you're going to learn, and again, you're going to see the judge doing his own cross-examination here, is you're going to see that the data was extracted from the CPAP machine, and it was used in an open source software that this data analyst got from the internet. It was not certified from the manufacturer. There were no protocols or checks being done, and you're going to see that one of the concerns is that the way the way it calculates the data is it says that there was no missed days at all on the CPAP, except for the fact that Gary was hospitalized and spent an overnight at the hospital for one night, at least in 2018, in the springtime of 2018. Now, the concern on this is that, okay, it didn't document that, because that is the day that Gary would have been away from his CPAP and in the hospital, because he was rushed into the hospital. And yet the CPAP doesn't demonstrate that. So one of the concerns would be is that since this is not being read by the manufacturer's source, could this have skipped that day? And if it did skip that day, could everything be reading one day earlier? Because it didn't account for that day in the data. It's also possible as well that when it feeds all the data into this open source program, it could have the dates off. If the dates are off even by one day, and again, you're already going to hear in here that the CPAP machine reads odd anyways. Its normal days are from noon to noon, not midnight to midnight. That could this thing be off? Could this thing be off by one day? And since there were no checks done, we don't know. So as a result, we go from saying we're certain that Gary could have died on the 3rd to now, oh my God, maybe we're not so certain. And again, when you couple that with the cell phone evidence of Gary's phone moving all over that property, and then you listen to the business associate who we heard in my live on Friday talk about the fact that she gave him a sensory filled description of Gary being alive because she smelled his cigarette smoke on the 4th when she woke up when she was moving around the property. And we know Gary's phone was moving around the property, moving around the burn pile and doing all of that. And then we also, as you're going to see, there is an overwhelming amount of evidence suggesting that that burn pile was not lit on fire until the 4th, the afternoon of the 4th. And that it was pretty much scientifically impossible that it was not lit on fire on the 4th, and that Gary's body ended up on the burn pile on the 4th. You start to question now and think to yourself, oh my God, is it possible that the CPAP was wrong? And it could be, right? And then you go in there, well, hold on a minute, let's look at the validity of the data. And then you find out that no, this guy shortcutted it. He went on and he got some unsubstantiated open source program, does no protections, does no controls, and then presents this data in court, and we find out now we don't know. And that's what this jury's sitting back there struggling with. We now don't know when Gary died. Because there is no other evidence than the CPAP. Now there are things that he never, answered emails and things of that nature, but it's a holiday. So that's not necessarily going to be suggestive of anything. But what we know is his phone stops all activity on the evening of the 4th. We know his phone is moving all around on the day of the 4th. And then we know now that the neighbors are saying that burn pile was ignited. They smelled the burn pile burning on the 4th. And the expert says that burn pile couldn't have been ignited any later than 1:09 p.m. on the 4th, most likely later in the afternoon. And you've got a recipe now to suggest that we don't know what happened here. That now, of course, Rusty's phone call, irrelevant. All the activity on the 3rd means nothing. I mean, they're talking her talking to Rusty that late may have simply been her just being up late, preparing for the grandkids to come the next day. May have nothing to do with Gary's death. So let's move into this next section, because this stuff's going to knock your socks off. And if you're watching this in the trial and you're one of these people out here that's ignoring this, well, shame on you, because I don't think the jury is, because that's why we haven't had a verdict yet. But let's jump in and let's listen to this.
Box zone. Just briefly, he did the CPAP machine, the Dell computer, all that stuff. CPAP machine, he used an open source, which just means free, program to interpret the data that he extracted from the SD card taken out of the CPAP machine.
All right, the CPAP machine. You didn't attempt to utilize get someone to give you access to the CPAP program approved by the manufacturer?
I had started down that route, and that's when I discovered this open source project, that the open source license project that has the ability to read the make and model for the CPAP machine that we had.
That is not approved by the manufacturer.
Correct.
That is a report format that somebody out there who's interested in this kind of thing created it on its own to extract the software and data and put in some format in some table that they think is appropriate for the data, based upon crowdsourcing and other folks that are interested in the same type thing.
That's pretty accurate for all open source projects.
Right. Not approved by the manufacturer who created it or their software that they have designed to go with the system.
Correct.
So it might be correct and it might not be. It could be the same as if I wrote it.
The documentation I read said it had full support for the CPAP device, and
From
the
other people who wrote the code to
Yes.
extract the data and put it in the tables.
Correct.
All right. Anybody else got any questions based upon my questions?
I'm sorry? I have no follow-up, Judge.
Now, with what the court had asked you about the program you used to analyze the CPAP statistics, what did you call it again?
The name of the program is called Oscar.
Okay, and that's just a program that you found online?
Correct.
Okay, open source, which means free.
Yes.
And did that program, because my understanding of your testimony was that you looked at the raw data and put it into, at the request of the DA's office, into some type of readable format, right?
Utilizing a program named Oscar.
Okay, so it's actually the program that put it in this readable format, not you.
I mean, I navigated and generated the reports through the software application.
Yes. But it's actually the software that's organizing it
Correct.
when you put it in.
Yes.
All right, so basically you're just reading what this report says when
Correct.
it comes out of the other end. But, it's like a hot dog machine. It's like you put in some information, it tabulates it, and then you read the report it generates.
Correct.
Okay, so you didn't actually do a review of the CPAP machine to make your determinations. You're reading what a computer program did, correct?
That plus the dates from the raw data on the initial CPAP reports that were produced.
While you were inputting that data, did you ever do any tests to make sure that it was operating and functioning correctly?
Looking at the dates and times from the initial CSV file that we had, or the Excel spreadsheet, the Excel spreadsheet and the initial output just defines a date and time that a log was generated, not the contents of the log, which is where this software application came in and read the contents of those log files.
Okay, well, here's my question. Did you ever do like a test, like, hey, I need to see if this program is actually working. So let's put in July the 1st and see what it tells me and see what this program spits out on the other end.
Not specifically like that, no.
Okay. Because what I'm trying to figure out if there's any way that you could have limited the possibility of error. Let me ask you another way. Did you just essentially put in all of the raw data that you could from the CPAP SD card into this program?
Yeah, the only way it allows you to display files, I can't pick and choose what information is inputted into this software application. It is uploaded directly from the SD card.
Okay, so you have to kind of do it all at one time.
Correct.
All right. So if there was an error in that Oscar program, you wouldn't know, right? Without having to go through and correlate it with all of the raw data that you had.
Correct.
Okay. And yet again, like Judge Cannon had asked you, that program, to the best of your knowledge, isn't licensed by the CPAP manufacturer.
It is not.
Nothing else.
I have no questions, Judge.
We had asked him, was that program approved by the CPAP manufacturer? No. Did you do any testing to make sure that the data coming out is correct and you can actually prove it that it's correct, verify it, when it comes out the other end? And he said he didn't do that because he had to essentially just dump all of the information into the program, and that's what it spit out on the other end, all the dates and the usage and all of those things. So remember I asked him, I was like, why don't you just take July the 1st, plug it in, see if the data comes out and matches, then you've got it verified that this program's actually doing what you would expect it to do. And he said, well, I can't do that. I have to do it all at one time. So essentially we have a non-approved or tested open source computer program to translate the raw data from the SD card. So you can't determine the accuracy of the translation. Even Box couldn't say that it's correct, what he was testifying to. He could just say, here's what this program that's not approved says.
All right, so guys, there you have it. I mean, the CPAP machine, and as you can see there, we're going to transition into the next section now, a very important section coming off of that, because the defense just showed, I just showed you the testimony, the judge helped out with this, and the judge himself demonstrates the CPAP machine can't be trusted. The data coming out of the CPAP machine cannot be trusted, and the CPAP machine is perhaps one of the most important aspects here that the state is relying on, because it's being relied upon to establish his time of death, because that is something that he would have used every single night, at least according to the data. But the problem is the data that we're relying on was read by a program that can't be trusted because it can't be verified. And that's a huge problem. So now we have time of death ruled out. And now we have to look to other areas, because now there's a lot of other areas that are potentially pointing to a different time of death. Number one being the time of the fire. And as you're going to hear, the time of the fire, you're going to hear is in great dispute. And you're going to hear the scientific evidence that's disputing that. You're going to hear the eyewitness evidence that's disputing that. And this is a big problem that the state has. But this is, remember, these things are in the jury's mind. This is stuff that the jury has written down, has watched, has paid attention to, is not being blinded by other things that we were seeing. They were in the back jury room walking around, getting their steps in. We were getting our minds tainted by seeing all of the hearings that took place outside of the eyes of the jury. We're hearing about MJ and all these different things. We're going to talk about that because that's going to come up here later. And the perspectives that everybody that we have versus what the jury might have. But this is huge. So we've just eliminated, for purposes in a court of law, the judge himself eliminated it in front of the jury and said, okay, CPAP is now irrelevant. The data can't be trusted. So now we do not have an established time of death. So now you're going to see where the data and the science of the fire is going to come in, along with eyewitness testimony. That's going to come in, and it's going to completely throw things for a loop. So as you can already see, we're just mad that the state's case is essentially collapsing in and of itself. That's what, and this is why in that jury room right now, people can't understand why is this not such a quick verdict. Well, because you've got suspicious behavior from Scott. You've got the CPAP machine that was supposed to establish the time of death can't be trusted, so you have no way to determine the time of death. Now we're going to get into the fire, and then we're going to get into the fact that Scott is the only person that would have been available to have started that fire. And now you've got a real problem. And then you run into all the people to say, well, maybe the way Melody got him down to the fire is he had already started the fire and she goes down and shoots him. Well, this was something that has popped up a few times in my comments. And they said, well, how does that make a difference? How does this, he could have been on the burn pile already. No, because he wouldn't have been down there near the burn pile. And he's not going to be starting a burn pile at 2 a.m. in the morning. That doesn't make any sense. Especially when you look at, if you go back and you do look at the CPAP data and you see he normally goes to bed around midnight, he's not going to be down there doing anything with that burn pile at that time. And maybe he would have been at 10, but I don't think he would have gone right from arriving at 9:32, goes inside, and he goes right out to the burn pile at that time. That doesn't necessarily make any sense. So what do we have here? We have a situation to where if the fire's already started and he's down by that fire and he's already started the burn pile and he gets shot near the burn pile, then that would mean that whoever shot him, or whatever time that would be, is whoever's going to be on the property. Well, if that fire couldn't have started until after 1:09 p.m. on Saturday, or not Saturday, on the 4th, and at 1:09 p.m. Melody is verified to be off property, and the only person without a verifiable person in the world who can put eyes on them and tell them where they're at is Scott, and he's no longer got an alibi because nobody knows where he's at. And they didn't look at geofencing location for that afternoon. It's not present. We already went back and watched that testimony of the cell phone expert. And we have the friend, as you're going to hear later on, you're going to hear his best friend say, I left and went to a friend's house. I went to a pool party. And I came back a few hours later, and then Scott was still up there. Well, is it really believable that Scott's just going to be up at the lake house alone while this guy's over at a pool party? Sounds to me like what really happened is Scott didn't go. He went back to the house and he started the fire, and he burned up his dad's body. And then he returned to the pool party for about an hour just to show up, and then left and went back to the house to finish it out. And the neighbors, the junior medical examiner, as you're going to hear from her, says, yeah, I smelled that fire burning on the 4th. And there it is. And the in-between, we don't know. How it went down, where it went down, whatever, we don't know. But what we know, and what we're about to come up on, and what you're about to hear, is you're about to hear the scientific evidence that proves this fire could not have been burning on the night of the 3rd. Thereby, if the fire wasn't burning on the night of the 3rd, then the statements that Rusty claims to have heard were absolutely false. And they were made up, or they were mistaken, or they were just whatever. But they're not, they have nothing to do as far as implicating her in this crime, the way many people have used and believed that those statements are the linchpin in convicting her. And this is what this jury is struggling with. If you have an expert witness who says this fire couldn't have been going on at that time, and you have Rusty who's telling you right now, I made a mistake and I made it up and I was scared to death I was going to get charged. And there it is. You wonder why the jury's struggling to come to a verdict. Anyways, let's jump on here and let's hear this fire expert information.
Now this is Dr. Pope. That's just a little snippet of her report, because I just wanted to read basically her findings to you. She said that that's easier if I just read it. The fire that burned this victim's body is consistent with a single burn event where the fire was set and left to burn as a slow rendering fire. And then for some reason it says in parentheses hours. that remained undisturbed until discovered as a crime scene on July 5th. The duration of the fire was less than 24 hours old. You'll remember from her testimony, she made that assumption based upon how hot the fire was when law enforcement arrived on July 5th, somewhere around 1 o'clock or so, 1 o'clock, 2 o'clock, whatever that is. Now the important thing is, that 24 hours. I also wanted to point out, so post testimony that Gary's remains are in that state of cremation, being on the burn pile 24 hours or less. Okay. You remember from those interviews you were hearing where Kuykendall and Hayes are talking to Melody, saying that we've seen people come out of house fires. We've seen people die in collapsed house fires, and they don't look that bad. They're not burned up like that. According to the sheriff's office, they don't even believe their own expert. But she said it happened in less than 24 hours. And not a house fire, an open pit just laying there, burning. And also, no accelerants. No gas, no alcohol, no nothing. Now, the reason that 24 hours I've always thought was curious. So, if the fire was 24 hours old, 24 hours old when they arrived on July 5th, 1, 2 o'clock, that means that the fire had to be set less than 24 hours or less before. So that'd been 1 or 2 o'clock on July 4th. Common math. Actually went over that with Pope, and she agreed. Because I do remember. I was crossing here and it was 1:09, if you'll recall. I was like, it is 1:09 p.m. right now, 24 hours ago. It was the day before at 1:09 p.m. and she said yes. So
trauma.
So is it fair to say you had a specialty within forensic anthropology?
Yes.
What would that be? What focus would that be on?
Mostly burn bone, but also how the human body burns during different types of fire events.
And have you performed experiments on cadavers with fire?
Yes. So my research that I've been doing since 2004, for several years. Basically, I test on human cadavers. So we put them in structures, in vehicles, in outdoor scene conditions, and this is for law enforcement training. So we're able to show them how the body burns in those different environments, as well as outdoors, confined space, and others. And so we document time, temperature, photography, sometimes video, so we can see all the stages from start all the way to finish when the fire is put out, which could be minutes, it could be, an hour, 2 hours. It just kind of depends. So we kind of test all the different ranges and figure out how the human body burns in those different types of fire environments.
What would be the number of bodies that you've burned throughout the years?
I'm up to about 270. It's part of a training course that we do each summer out in California, and we do, it's a law enforcement training course for about 65 investigators from all over the country. We get people international as well, and we average about 15 to 17 bodies a year that we do fire investigation training on.
Before we get into the details of this case, can you explain to the jury generally, if you could, how a body will burn, the process of that once it is, I guess, for lack of a better term, set on fire?
Yes. So the body is layered in tissues. It's got skin. It's got, underneath that is going to be subcutaneous fat. Underneath that is going to be muscle. And then you have organs. And then my specialty is the bones inside. And so each different tissue burns differently. The skin is really thin. So when it's exposed to heat, it'll start to shrink and pull apart into little skin splits. And this exposes the next layer of tissue, which is going to be subcutaneous fat. Now, subcutaneous fat burns as a fuel source. It is a lipid material, and it turns into basically grease. and it'll fuel the fire, especially if it's absorbed into wood, clothing, anything that will retain that. And so that is a major contributing factor in this case, as well as my experiments in terms of after setting the fire, the body can actually burn on its own rendered fat, liquefied fat, for several hours, just as the main fuel source, even after ignitable liquids have been expended.
I want to walk through your report here. Did you have a recorded temperature at the time of the discovery of the body?
It was mentioned at about 100 to 230 degrees Fahrenheit.
Was that helpful for you to start your analysis of possibly the time that that Mr. Farris had been on the burn pile?
Yes, so the fact that there was still heat and temperature there just lets me know that it was a more recent event, in that the fire was able to go out on its own, but it was still warm. If it had been cold, that could extend the time period. But in this case, the coals were recorded at a low temperature, so that kind of lets me know that it's a more recent event, under 24 hours, as opposed to later on.
And had those temperatures been lower, or like cold or ambient, that would have done what with the time frame?
It would just expand it potentially. It basically just the warm coals just kind of put it at a lower or a shorter time frame.
And does the fuel sources surrounding the body or under the body or over the body also depend on how long that may have been burning?
Yes, absolutely. So the more fuels in the fire, the longer it's going to burn. If there was just a few little, pieces of wood, it wouldn't burn quite as long. But in this case, there were pieces of wood at the crime scene. And so that kind of gives me an idea of the potential fuels that were there, not the exact amount. But with the wood being there, that's going to absorb the fat, and that's going to keep the fire going and fuel the fire for a long period of time, over several hours. It was reported that it was still warm.
Still warm. And you state in your report, you don't have an exact timeline, but you state somewhere less than 24 hours.
Yes.
Okay. So if law enforcement is recording the fire around, let's say 1 p.m., right? Less than 24 hours would be the next day at 1 p.m., or that would be exactly 24 hours.
Okay.
Okay. Is that right? In 24 hours? Like 24 hours from now, 24 hours from now will be 1:09 tomorrow.
Oh, okay, yes.
Yeah. So if I go back in time, trying to calculate something else, 1:09 yesterday would be 24 hours.
Yes.
Right? All right. So the fire was started or was recorded on July the 5th around 1 p.m. That would mean less than 24 hours would be July the 4th at 1 p.m. Correct?
Yes.
Okay. Now, you also state that you didn't find from the photographs any evidence of stirring or stroking or anything like that.
Not based on how the remains were found.
Okay. Now, that's what I want to show. Did you review Dr. Gooding's documentation? She did the anthropological report.
Yes.
Okay. She also attached with that a photograph, a chart. And it's been admitted into evidence Gooding 1. Can you see that on your screen?
Yes.
Did you review that chart?
No.
Well, you were provided her report, correct?
Yes.
Okay. Now, what it says, and I was talking to her. It was an eyewitness, in this case, that previously had testified that he observed flames from the burn pile on July the 3rd, later in the day.
Get my notes real quick.
Would knowing that information change your opinion about your report?
I mean, it's possible they could have started, had another fire earlier. I'm not sure.
Okay. But it's still your opinion that this fire was less than 24 hours old?
Yes, simply because it was still warm. If it had been cold, then we could extend the time frame.
Okay. All right. So 1 or 2 o'clock, law enforcement's there. Fire's burning less than 24 hours old. Well, at 1:54, Melody is an hour away on the 4th of July, verified at Lake Lanier. So we know that it's about an hour or more on a major holiday to Lake Lanier. Amanda said traffic was horrible. Getting in was horrible. Also know Melody went to Target, had to go buy the chair. We don't know exactly when she left, but through the state's expert, it seems like less than 24 hours, unless you just want to say, well, less than 24, maybe it was 10, maybe it was 5, whatever. Use your common sense there. But if you put it around the time of 24 hours when that fire was started, according to their expert, Melody's in Lake Lanier. She wasn't even on the property. And that is verified by that receipt, that is verified by Amanda, that is verified by Cameron as well, that Melody wasn't at Purcell Lane, that she was at Lake Lanier.
So once again, guys, there you have it. I mean, you understand now why the jury's struggling. You have an expert witness called not by the defense, but by the state, paid for by the state's dime, propped up by the state. The state puts her up as a witness, as an expert witness. Not even sure why they called her, because what does she do? She absolutely destroys the state's case, in my opinion. And she destroys the state's case because she demonstrates in front of the jury this fire could not have been more than 24 hours old. Meaning, at best, this fire was started at 1:09 p.m., meaning Melody wasn't even on property when this fire was started. Or it may have been started maybe or 2 o'clock or 3 o'clock. But there is one person who does not have a witness as to his whereabouts, who does not have anyone accounting for where he's at, who was about 45 minutes away from the house, and whose friend was leaving around noon to go to a pool party, to which he did not return back to as per his story, he did not return back to his lake house to join up again with Scott until about 5:30. Meaning Scott had about 5 hours to which he could have returned back to the house and done what he needed to do. If Gary was alive and Gary was already starting to do his burn pile, which is what he said he was going to do to celebrate the 4th of July, does a confrontation happen there to where Scott shoots his father, puts him in the burn pile, burns him up, and then realizes I need to get back up to the lake house to make sure I have an alibi so that when when my buddy comes back, he'll see me. He goes to the pool party, stays there for about an hour and returns, and then continues to monitor the fire until it burns itself out overnight with the rain showers that come in. And of course, we heard what you're about to hear. The next segment is going to be from the neighbor who confirms and establishes that this fire, again, was not burning on the 3rd. It was burning on the 4th. She did not report smelling any fires or any sense of fires or any sign of a fire on the 3rd. She's going to tell this jury it's on the 4th. Again, this is a witness called by the state. Not only was she called by the state, but she actually is one of 4 investigators who claimed to find this bullet in the rib cage in the burn pit. Okay, so she's a very important witness whom the state says is credible. And she's sharing with the jury that she smells a fire burning on the evening of the 4th. Okay, so that is absolutely damning evidence for the state's case, because we know the evening of the 4th, Melody's with her grandkids. Melody's inside the house. The grandkids say she's inside the house and she's inside her bedroom. There's only one person that's out on the property who would have any opportunity to be dealing with any burn piles. That would be Scott. So again, this is why the jury's struggling with this, because you might say, well, she had to be involved. Well, maybe she did. But the problem that you have is you don't know what she did. And you don't know if she shot him. You don't know if she, or if she just simply became aware at some point that Scott did this. Or maybe, she did this and Scott's helping her burn the body. We don't know. And that's what the jury's struggling with in the back. That's why the jury's asking for the law to come out, because they're trying to figure out. So if we think she's involved, but we don't know how she's involved, what can we find her guilty of? And what they're going to find out is there's really only 2 charges that would allow them to hold her accountable in that way. That would be charge 4 and charge 5, concealing a dead body and lying to an officer. But then the question is, what did she lie about? Or did she even lie at all? And these are the problems that the state's case has, which is why this jury is struggling and is going to continue to struggle with this case if they ever come to a verdict. If they can ever get 12 people to decide what to do with this case. This is a very difficult case. But I hope that you're starting to see now why this isn't the open and shut case that many of you who have come into my comments, I've seen you in other comments, are coming in and saying, how could this jury be struggling with it? How can they not be? This is what the jury saw in the courtroom. These issues right in front of them. They did not have, like I said, they were not distracted with any of the exterior things that have been going on that we were privy to. They have been sitting in that courtroom digesting this information. Anyways, let's jump on and let's listen to the neighbor now. The neighbor and the medical examiner, junior medical examiner, testify here regarding what she saw and heard and what her husband saw and heard.
Of the heat. Now, you lived very close to this property. You noted some things that you had observed prior to and the days leading up to this. Can you tell the jury about what the weather was like the days prior to finding these remains?
So, my house is kind of kitty corner across here, and usually I had 2 horses down the barn, and it was 4th of July, and the people behind us were always setting off fireworks, and I could smell burning. And I told my husband, can you just walk down to the barn and make sure there's no fireworks or anything, everything's good down at the barn. And I was standing outside in the driveway, and he came back up and said, I don't smell anything down there. And I thought to myself, it's coming from the left side, which I had never smelt anything from the left side. Usually it's from behind. So I was like, oh, somebody must be burning things over to the left, way left. And that night, I remember we had isolated like rain showers because I was happy. I didn't have to worry about the horses with the fireworks.
And that was on the 4th?
Yes.
And when you say the left side, what direction is that?
Let's see, that would be south, north. It's the north from the Forsyth County line.
Is that in the direction of the Purcell Lane property or a different
Correct.
direction?
No. In the direct, like 11 o'clock. If I'm standing in my driveway, it's 11 o'clock. The Purcell house.
When you are called out to a scene and you have to gather information to determine how an individual passed, is that accurate?
Yes.
You receive a lot of information from, let's say it's an investigation. You receive information from the
Yes.
investigators to make that determination?
Yes.
Ms. Sims, I want to talk to you about a little bit of your experience as a coroner. You deal with a lot of dead bodies.
Yes.
Okay. And have you dealt with individuals more than 250 pounds?
Absolutely.
Have you been able to maneuver those individuals on your own?
Yes.
How so?
I mean, we can put slide mattresses. You know, we have sliders that we can put them on. It depends whether you're moving. Is there 372? Does it show Highway 372?
Okay, you see aerial 2 here? Can you see it on your screen?
Yes.
Okay. You were talking about you spelled something. Where are you at? On the 4th.
In my driveway.
I know. Where is that? None of us know.
Well, it's off of 372.
Off of 372?
Highway.
Okay. In this photograph, can I see your house?
I don't see my house.
Okay. So it's none of these houses here, right? Let me make it easy for you. This is Hickory Hill Road.
I am not on Hickory Hill Road.
This is Hickory Hill Court. That's not you,
No.
right? All right. This is Purcell Lane. That's not you.
Correct.
Okay. And in this entire photograph, I can't see your house.
You are correct.
Okay. But you're saying you live close enough to the Farrises that you can smell burning.
Correct.
Okay. How far do you live away from 2155 Purcell Lane?
I'm on the left. I'm off of 372.
So you're north up on like Birmingham Highway?
South on 372.
Okay. So,
When you come out of Purcell Lane, go left.
okay. Like, is that a mile away?
About a half a mile.
About a half a mile away. Okay. And you're standing in your driveway. And you can smell something and you're sitting here telling this jury that you think it was coming from Purcell Lane, a half a mile away. Can you even see their house?
Cannot see it, no.
Okay. So you're just looking through the trees being like, that must be 2155 Purcell Lane burning something.
No, I can smell it from that direction.
Okay. Did you know when you went out there that now you've not only there as a coroner, but you also made yourself a witness in the case?
Correct.
Did you notify anyone of that?
The detectives?
Okay. Do you think they put any of that in any of their reports?
I wouldn't know. I haven't seen their report.
Okay. I think we'll be asking them about that later. Didn't you think that it would be important if, hey, I may be a witness in this case? Maybe I should let the elected coroner know?
Earl Darby, coroner, was notified.
Okay. Is that in your report?
No.
Don't you think it would have been prudent at that point in time, since you may also be an eyewitness, that another deputy coroner should have been out at the scene?
I'm sorry, can you repeat that?
Since now you may be a potential eyewitness in the case when you get there, that possibly another coroner should be there who is more independent.
Another deputy coroner was there.
Who was that?
Blaine Ross.
Was he working in the fire removing the remains with you?
He was.
Who was in charge of Mr. Ross?
So there you have it, guys. There is the more testimony, more proof that this fire started on the 4th and not the 3rd. And again, I've told you what the implications of that mean. I've told you that that takes a lot of theories out, because if this fire started on the 4th, then Gary either has to be alive on the 4th or he was killed on the 3rd and stored somewhere and then burned up on the 4th. And if this fire to burn him up starts at 1 o'clock or slightly thereafter on the 4th, Melody couldn't have been there to done that. That means that she had help at a very minimum, or it could also mean that she wasn't involved at all, or that she at some point became aware, because we know she was using credit cards and things, that she became aware, or Scott made her aware of what happened. And we know, okay, based on the cell phone data, that they were great friends, that they went out to lunch together. We know that the very last time that Scott saw his dad was at the lunch spot that they went to, and that he and his mother were having lunch, and they didn't even talk to his dad. We know that them having lunch was a common occurrence. We know that Amanda Farris said that Scott and his mother were very, very tight, that Scott liked to decorate, his mother liked to decorate, that they were friends, and they went to the store together, and they bought things, and they decorated the house together. So this idea that Scott tried to perpetuate on the stand, that he and his mom were mortal enemies and didn't like each other, why is he trying to perpetuate that? And it would make sense that if something happened and he and his father end up in this place, if he and his mother are close, that he might have turned to his mom at some point and said, "Mom, this is what happened." And that would explain why she's heading to the store to go buy things at Walmart, maybe to clean things up or help Scott clean things up, and beginning to say, okay, well, we can't bring Gary back, but we can at least try to make sure her son doesn't go down for it. And then Scott does a turn, right? As this thing is starting to get discovered, he double crosses her and says, I'm putting it on mom and I'm taking the whole property, just like he told Lambert, the alarm guy. He says, I can't wait till they're both gone and I get this property to myself. And he thought, I see the opportunity. Again, here's the thing. What we're talking about here is, why is the jury struggling here? Because exactly what crime do you find Melody Farris guilty of out of the 5 that she's charged with? And which one of those 5 can you say has been proven beyond a reasonable doubt? And you can already see the struggle here. You can already see why this jury is struggling very, very badly with this case, because there are problems with this case, and you're seeing them as we're walking through this. Now, this next section is going to deal again with the Scott Farris aspect. This is going to blow Scott Farris's idea. Any of you out there who believe Scott Farris had an alibi, we've just heard when the fire hadn't started. And now you're going to see he's got a big fat hole in his alibi as far as for where he can be accounted for and where he can't be accounted for. And you're going to see that now. So let's jump into this.
And so is 10:55 the time that clip saved?
Yes, ma'am.
So once he left that night, when was the next time you saw Scott?
The next morning at Hampton Golf Village, we had I believe a 7 a.m. or 7:15 a.m. tea time.
When you arrived at Hampton Golf Village, was Scott already there?
Yes.
What time did you arrive?
I believe Philip and I arrived around 6:45.
Had you heard from Scott before arriving at the golf course?
He did text me a little bit earlier that morning asking if we were awake and ready to go.
So you golfed at Hampton Golf Club that would be the day of the 4th?
Yes, ma'am.
How long did it take you to do that round?
That round was probably about 4.5 hours. Typical round.
18 holes?
18 holes, yes, ma'am.
So that puts you around lunchtime.
Correct.
What did you do next?
We went directly back to the lake house.
Who's we?
Me, Scott, and my brother-in-law, Philip.
So did Philip golf with you that day as well?
Yes, ma'am.
You went back up to the lake house. Did you guys stop anywhere?
No.
Once you got to the lake house, what did you do?
Probably went back down to the dock, went back out on the boat for a little bit. I left at some point in the afternoon for a few hours to go visit a friend at, I believe, a pool party in downtown Cumming, and then came back up to the lake house a little bit later.
Was Scott still there when
Yes,
you
ma'am.
arrived back? And did you guys go back to that pool party later that
We did.
evening? Tell the jury about that.
After I got back up to the lake house, everybody had kind of started packing up to go home. My mom went home. My sister and my niece and my brother-in-law went home. And I was planning to go back to the pool party, and Scott came with me because it was on his way home. So
What time was that, do you think?
probably around 5:30, 6 o'clock, I'd say.
How long was that drive from your lake house to the pool party?
About half an hour. 20 minutes to half an hour.
How long did you stay at the pool party?
I don't recall how long I stayed. I might have been there a little while.
How long was Scott there for?
Maybe an hour,
He
hour
did
and a
not
half.
stay as long as you
He did
did?
not stay as long as I did, no ma'am.
Did, when Scott, let me go back to the night of the 3rd. When Scott left the night of the 3rd, did he say why he was leaving?
He had gotten a phone call from his mom, and the horses had apparently gotten.
right, so let's talk about that before we talk about the next segment. And that is where, again, more suspicious stuff from Scott, which is regarding the bullet that's found only after Scott enters the basement, leaves the basement, and then the bullet gets found. But let's talk about what we just heard from Scott's best friend. What does Scott's best friend do? He tells this jury that they go back to the lake house and he leaves for a few hours and then returns. And when does he leave? He leaves right at the key time that the fire expert says this fire was started. Right in that time frame. To which, if you listen closely to that fire expert, she says about 2 to 3 hours it's going to burn. There was no stirring. There was no evidence that this person was tending, that anyone was tending to the fire continuously or stirring the body or moving it around. It was ignited. It was started. It burned strong for 2 to 3, 4 hours. And then after that, it kind of simmered. It started burning off. And it burned for a while because it was burning off the fat. It was burning off the wood. It was fueled, which would mean about maybe 4 o'clock, Scott leaves, starts the fire about maybe 1:30, maybe 2 o'clock. By about 4:45, 5 o'clock, he leaves and heads back up to the lake house. Gets back up there just in time to be seen. Or maybe he went directly to the party. Who knows? But according to his friend, he was back up at the lake house when he arrived back. And then they went back to the place that he had just come from. And then, lo and behold, Scott leaves about an hour after he's there and heads back to his house. And then the neighbors are smelling that fire burning as it's burning off. And Melody eventually arrives with the grandchildren. And the rest is history. And there you have it. The only question is when did Gary die? We don't know. We still don't know because the CPAP machine isn't reliable. So this jury is sitting here with this information in front of them. It's been testified to them in front of them. They've watched Scott get accused by the defense, walk through this entire process where we watched the testimony. We heard about the money. We heard about the way he's the way he had no job and all the money he was spending of his father's. We heard contentious text messages all over money. You hear that there's hundreds of text messages and calls between him and his mother. We know they're going out to lunch on a daily basis. And yet everyone here wants to say, oh, Scott was this, confidant of his father's. Did not appear to be that way. Did not appear to be that way, at least if you really closely read the messages and you look at who's communicating with who. And then you listen to the interactions that they had when there was a alarm guy there and the things Scott said. Anyways, let's continue this path, okay, and continue to listen to the evidence as it stacks up against Scott, the suspicious behavior. Remember, what you're about to hear happens all in the same time that he's deleting the trail cam. He shows up in the basement. A bullet shows up there that the grandkids were playing in that very basement, walking around that very basement the night before, looking for Big Daddy the night before, and they did not find or see any bullet or blood in the basement at that time. Anyways, let's jump into it.
Messages. It's 8:30 when she tells them to take a bath. They sneak out of the house, go get in the hot tub. Now, what's important, what Cameron actually establishes is Melody wasn't acting weird. Melody wasn't restricting them to go outside. That they went up to the barn. They went and looked at the horses. They went and saw the animals. They looked for Gary, and both of them confirmed they were down in that basement, and they didn't see any blood or any bullet. Nobody did. Nobody did on the 4th or the 5th. Anybody that was in and out of that house. Oddly enough, the last person, best you can tell, is the last person to come out of that basement is Scott before law enforcement gets there, looking for his magic gun that nobody's ever found and that nobody's seen. He's the last person to come out of that basement. And then the bullet is found. Chief Deputy Pinion And Chris and Emily wanted to get on the stand, or did get on the stand, and basically say, oh, Daddy dearest, I loved him so much, I miss him, I can't believe this. While at the same time, you got Chris robbing him blind, him actually saying he was stealing, him admitting that he had used his bank accounts because he had the account numbers and all that, which is illegal, and he was doing it without Gary's permission. Gary actually texted him and said, your stealing has got to stop. Scott texted Melody saying, is he gone? Wanting to know if Gary was gone so he didn't have to do anything anymore. That is not, those aren't the text messages of somebody who, you truly love this man. No, that was just their bank. And he was getting ready to cut them off. So Lambert, that weird interaction, he said, it wasn't fisticuffs like Mr. Fogus likes to say. It didn't rise to that level, but he said it was just weird. And then Scott making the statement, can't wait till you're gone so I can get this, or something to that effect. That's weird. That's not the statement of somebody if you love your father. Dave Thomas, yet again, showing Scott's aggression. With a whole, Miss Frankish, she got up here in her opening and was saying, well, Scott's dad was dead and he had a right to be upset. And then she said, his trailer. That ain't his trailer. That's not his property. That is Melody and Gary's. He wants it to be his, but it's not. Just like they want the money, they wanted the house, but it's gone. They wanted everything. They acted like it was theirs, but it wasn't. And Miss Frankish bought right into it, came up here and told y'all exactly that. He's upset his dad died. He's got strangers using his trailer. It ain't his. The owner of the trailer was standing next to it with Dave Thomas when he comes up acting like a nut, then chases him halfway over to Forsyth. Here's where they messed up though. It was with the financial accounts. You'll look at those. You should have them back there with you. Gary had actually added Melody back on as a life insurance beneficiary in 2012. That's around the whole Ted Wiley fiasco and her leaving in Alabama and all that. She added him back. Here's where they messed up. They did not prove that Melody knew anything about the existence of life insurance. There's not a single witness who has said Melody knew about the life insurance policy, that Melody knew that she was a beneficiary. In fact, you heard from their own witness, Martha Jane. She said Melody didn't know anything about their finances. She didn't know where the money was. She knew that she had a debit card and that she could use it, and a credit card, and that she could use it, and that Gary tracked her. But she didn't know anything about other than that. She didn't know anything about the life insurance. She didn't know anything about the 401k. She didn't know about the partnership stuff though, because she called and asked about it. But that's it. They want to say that money is the motive, then you might want to establish some evidence that the person who's wanting the money even knows the money exists. The only thing that Melody knows about money existing in this trial that is a proven fact is a receipt in her car with $11,000 in the bank account. So with that, I'm going to just go ahead and end there. And all of those out. And John Luke sat there listening to interviews, flipping through photos. And then I started going through and flipping through photos. And then we started noticing that, Scott living in the barn and, he's a 30-something-year-old man, probably not going to be very clean. It wasn't too bad, but his living quarters, pretty nasty. Dog feces all on the floor. Not the cleanest, I'm kind of a clean freak, so I pick up on that. But what was curious to me, a 30-something-year-old single man living in his parents' barn, that bathtub and that sink are spotless. And law enforcement took no initiative to say, okay, this is kind of weird. The rest of the house ain't too clean. Why is this absolutely spotless? And also, there's a magic eraser in the bathtub. I mean, at a minimum, could blue stars. What if he was washing off blood? But we don't know, because they don't have initiative. Same thing, you'll remember, you're probably wondering, why in the world are they putting these in the photograph? And I don't have it on a slide, but you'll remember downstairs in the barn, I think Mr. Fogus put in some and I put in some too. There's that drain and there's a water hose running over to the drain. We actually took close-ups of it. No blue star at all in the barn. And they had, they can't use the old, it's expired excuse because they called Renee out there. And I asked Renee if they asked you to go out and blue star the barn. What'd she say? Nobody asked me to.
All right, guys. So, look, we just walked you through it, okay? And there you hear it. Just the final pieces here. We have, Scott enters the basement. Nobody else is seeing bullets down there. The grandkids are down there. Nobody else is seeing bullets down there. No blood is seen down there. Not to say it might have been there. It might have been hard to see the blood, but certainly no one's seen a bullet down there. These grandkids are down there walking through there the night before. They're running all over the property. They don't see it. Scott, once again, goes into the house. Why? Because he says he needs to search for a gun that he claims is missing. He starts telling everyone that there's this missing gun. He goes in. He goes downstairs, and lo and behold, there's a bullet found in an odd place with no indication that there was anything that happened in that area, that there was a shooting, nothing. No impact wound, nothing. No impact spot, no blood splatter, no indication of how that bullet made it there or why it's there. There's 4 very small blood droplets around. We know Gary, by virtue of other testimony, that he had been bit by a dog previously and had come down those steps with that dog bite bleeding to go treat it and tend to it. We know, so more likely than not, that's what the source of that blood was. Surely wasn't him being shot, because there wasn't a sign of any of a lot of blood. There was 4 minute drops of blood in that area. So you have that. Then you have Scott running around telling everybody, hey, there's a gun, there's a weapon. How did he know? How did he know that it was a gunshot wound? On top of that, you have Scott telling everybody, or he tells at least his brother, Chris, we're to assume Chris got it from him, that it was a .38 caliber bullet that was found, or bullets that were found. How did Scott know that? We know Scott has .38 caliber ammunition found in his apartment when they do the search. We know Scott has a credit card he shouldn't have of his father's up there in his apartment. We know Scott, it's Scott who says where the wallet's at. It's in the car. We know all of these things are Scott. Again, there's one common denominator. At the same time, Scott is leading the trail cam. Okay. Now we know also Scott is relying on his father for money. We know that Scott was told months before things are going to need to change. We know that Scott was told that he was going to be using a specific bank account, which he claimed was not because of him, that it was more for his mom, but he had a specific debit card with a specific amount of money that would be put in. We know the financial situation was changing. We know Scott was wanting to get some fancy golf clubs. We know he had plans on the 5th to go and get fitted for those golf clubs. Isn't that suspicious? On the 5th, he's making plans after his father has passed away. He suddenly knows that he's going to be able to go and make a big fancy purchase. Did Melody make any plans for fancy purchases? No, Scott did. And he's heading there on the 5th, believing in his mind at that point that his father's burned up in the burn pile and he'll eventually get burned up. And then he sees Melody down there with Amanda, and he's mad. And that's what you hear Amanda Farris say. Yeah, he seemed to be scowling down at us. He made her nervous because she thought, well, what's going on? And at that point, Scott figures, you know what? Fine. This is my opportunity. my opportunity to get it all, get the farm, and become the man that I'm telling everyone I am. I'm telling everyone it's my farm anyways. My dad's gone. Now my mom can go to prison for my dad's killing, and I get it all, or at least, some of it all, but most of it all. And that's what we have right now. You heard the testimony that they were from his best friend, where they were going, that they had made these plans to go do this special fitting for brand new, very, very expensive golf clubs. To which, how did Scott believe he was going to pay for those? Did he believe his father was going to pay for them? Because his father was tightening up the ropes on him. Unless Scott now knew or now believed that, guess what? He was now going to have access to all the money with no problem. So now it's time to go start shopping for those new golf clubs. Then we learn about the shower, the pristine shower in the barn that was never blue-starred and never investigated. And there's no explanation for that. As the defense attorney says, they can't say that it was because it was expired, because they called in somebody with fresh Blue Star and they never asked her to go and Blue Star it. His apartment is never Blue Starred. There's a magic eraser found in the shower of a pristine bathroom in an otherwise dirty apartment. Right after we know there was a crime committed that would have resulted in him, especially if he's having to carry this body down to a burn pit or move this body down to a burn pit, that he would have absolutely, without a shadow of a doubt, had blood all over him, had dirt all over him, had a need for a shower. And they're not investigating that. They're not blue starring it. They're not looking into it. So you wonder why this jury is struggling with this case when you have another person who has the motive, the opportunity that fits within the timeline, is the only one who knows that he shot. And if you go back and you listen to the various tapes, to where Melody genuinely, it appears, did not know he was shot. In fact, she's believing and very genuinely telling everyone in there, I think the police are lying about the gunshot. That's not what you would expect her to be saying. You would expect her to be saying, no, he was shot. You would expect her to be saying to Rusty, he's shot, because that's what they're talking about, because that's what she would have told him, because that's how he would have died, and she would have known that. But there's one person who's speaking confidently about how Gary died, and that's Scott. This is why this jury is struggling. Now, there's one final piece that needs to be taken care of, and that is the idea, as many of you have said, and many of you said, well, she stole this gun from Martha Jane. But let's listen to the real story of this. Let's listen to the whole facts, because just like everything else in this, it's tainted. Just like the CPAP data, it's tainted because it wasn't used by the correct data, by the correct program to make sure the data was accurate. Martha Jane was tainted by YouTube and was tainted because she watched this trial unfold. And so all of the information she brings in about the gun, all of the information she brings in about the entire situation with this alleged gun that she told Melody about is completely tainted and cannot be trusted. And this jury knows that. So many of you who find it extremely credible from the jury's perspective and from the instructions they got, this is evidence they really shouldn't and can't rely on. Certainly not beyond a reasonable doubt. But let's jump into this and let's listen to what they have to say.
Jane. She's known about this case since July the 5th, 2018. I'm almost July the 5th, 2018. In the middle of this trial, she called law enforcement and said that I have to tell y'all something. Melody stole a gun from me in 2019, and it was a .38. And when did she say that? After, and you'll have this back there with you, after she admitted to it, after you watched this man on YouTube commenting over Rusty's testimony. And the title of this video, Did I Just Crack the Case? Because that man said, and I asked him, that's where the gun came from. The next day, she is on the phone with Captain Hands telling the story about how Melody stole her .38. There is no evidence that she ever owned a .38. They got some .38 bullets, but also just to show you, those are Winchester, not Hornady. The .357 that her husband owned was still there, and what? It also shoots .38, so it makes sense that you could also have .38s. But there's no receipt. There's not a photograph of this gun. There's her words 6 years later saying that she's got to go. Now she sat on the stand and said, well, law enforcement never asked me about no guns. Yet again, July the 5th or the 6th, she knew Gary had been shot. And you don't think that that might be relevant then? It only becomes relevant when a little man with a YouTube channel tells you that it's relevant. And she admitted to that. She also admitted that she was embarrassed. She was furious at this affair that she found out about, essentially on live television. Now everybody in Tullahoma knows it. She said she's got to hang her head whenever she goes. Rusty destroyed the Barton name, and I also asked her, you believe that a mother should always protect her children? She said, I do. And I said, when you saw John Luke and I crossing those witnesses, you were furious. And that's when Mr. Fogus started his objections about let her finish her answer. Let her answer. She's 85 years old. She might be 84 years old. She might be 84 years old, but she came up with this lie because of YouTube and this trial being on television. That's the only way that she came up with this. She wants to talk about, Miss Francis wants to talk about her picture is in the dictionary next to the word credibility. She has no credibility. She watched this whole trial. She knows everything. She knew to even say what color the gun was because she can go back and watch Scott's testimony. What does she do? Yet again, can't get the color right. She got the holster kind of right. She can't get the whole thing because you got to remember stuff when you're telling lies, and it's hard. And I'm sorry, when you want to show up in the middle of a murder trial, 6 years later, 5 years after you discovered a gun being gone, and your excuse is nobody asked me, and it doesn't become important until 2-3 weeks in, that's the definition of no credibility. And especially when you can't even prove to me that she owned a gun. And, you know, she's got an excuse for that too. Didn't like guns, she moved it all over the house, blah, blah, blah. Show me something. They got nothing. I'll go on for more.
So, there you have it, guys. He laid it out very nicely, the issues, better than I could, with why Martha Jane shouldn't be trusted. And everything he says is 100% valid, whether you like it or not. I understand there are a lot of you out there who say, oh my God, Martha Jane should be trusted, and that she is considered to be a linchpin in the in proving the guilt of Melody Farris. Unfortunately, she's not. And the reason why is because she can't be trusted, because her testimony was completely influenced by YouTube, because it was testimony that has been that you can't corroborate, because everything she heard, everything she said was already said in the trial. So as a result, from the jury's perspective, when they're analyzing that testimony, and when they're analyzing that testimony as per the way the judge told them to analyze it, it doesn't carry any weight. It doesn't carry any weight. And then on top of that, she can't even prove that she owns the gun, because again, there's a .357 Magnum that shoots 38s. So the fact that there's 38 bullets in a .357 Magnum does not mean that a 38 caliber gun ever exists, because the .357 can shoot the 38 bullets. Just like we know Scott Farris owned a .357 Magnum that is in fact missing, that we know did in fact exist, and that he cannot prove its existence or where it is, but we know it shoots 38 bullets, and we know there were 38 bullets found in his house, and we know there was a 38 bullet found in a rib cage of his father, and we know there was a 38 caliber bullet found inside the the house, which we know Scott was the last person in that area before it was found. We know Scott is the one telling everyone about this gun, telling everyone that there's a 38 missing, telling everybody that his mother is the one who did this, throwing shade on his mom. We know Scott is the one who had motive, because we know that he and his father, that their relationship as far as the money situation was becoming strained. We know that his father was telling him things are going to change as much as 5 months before. And we know that Scott, things weren't getting better, they were getting worse. Scott was moved off of being able to use the credit card and the family account, and he was told, you're going to use this debit card, but a certain amount of money will be put in, and that is as much as you can spend. We know that Scott was having dinner, having lunches with his mother, communicating with his mother quite a bit, all the way with hundreds and thousands of messages between he and his mom leading up to the day of his father's death. We know that the last time Scott ever saw his father, he didn't even bother to talk to him. That he and his mother were having lunch in the same exact spot, and he didn't even bother to talk to him. And that was the last time he says he ever saw his father alive. And he didn't even bother to talk to him. And those of you that say that's the sign of a strong relationship, what are you talking about? That says it all. That the last interaction that they allegedly have on this earth, he doesn't even bother to talk to them. They're in the same restaurant. I can't even imagine that. I cannot even imagine that. And then you take everything else. You take the lack of an alibi, because he's got no one to account for where he was at on the afternoon of the 4th. We know the fire expert says that is exactly when the fire starts. We have an eyewitness that says that the fire was burning on the 4th. We know Scott leaves and heads back to the property. He only stays at that pool party for an hour. We know then that Scott is ready to go make a big, fancy purchase. He's getting fitted for expensive golf clubs. He's heading there on the 5th when he encounters his mom and his sister, and he realizes that that his dad's about to be found, to which he takes over and he does the following. He deletes the trail camera. He claims that he has to go in and find a gun that he says is missing. And when he goes inside there to look for this missing gun, lo and behold, a bullet is found in an out of place in the scene, out of place in the area, but it's there. And then by his own suggestion to the police, he actually rises suspicion, as you heard in the testimony from the investigators, and you heard in the police statements when they're saying Melody was allowed to tell Chris what was going on, Amanda what was going on, but they did not want her telling anything to Scott, because they wanted to surprise Scott. They wanted to give Scott that information themselves. And then you have, like I said, the pristine bathroom. The barn is never searched. And are you still wondering why this jury is struggling? And then you say, well, maybe they're going to find her guilty maybe you're going to find her guilty of, something. Well, I think it's going to be difficult, because then you could run into the problem of how do you figure out what to find her guilty of? And the answer is there isn't anything to find her guilty of beyond a reasonable doubt, because you just don't know. But you have one person whom it's all circulating around, who is in control of the entire situation, and that's Scott Farris. He's the one person that was going to benefit, or was already starting to benefit from it on the 5th. That's Scott Farris. And that's why this jury is struggling. And that's why, ladies and gentlemen, we're either probably going to have a hung jury, or it's going to be not guilty, or it might be guilty of counts 4 and 5 as some sort of a compromise that this jury comes to. But when she's found not guilty of 1, 2, and 3, or maybe 1, 2, 3, 4, and 5, you've just learned why. And I think we've shown in this presentation, with supporting evidence from the trial, and this isn't everything. We didn't show the cell phone data that shows Gary moving all over the property. I've already shown that in previous shows. We didn't show the business associates who who testified about the very detailed, sensory-driven descriptions that Melody gave, showing that Gary was potentially alive. We didn't show the tapes where she says she's very convincing in the idea that she doesn't believe that a gun was even involved, that she thinks that's a lie that the police are perpetuating upon her. All of that exists, and this jury heard it all, and this jury is struggling with it all, and they should be. And since they are, if the jury were to be listening somehow, you got to go in and find her not guilty. That's what it calls for. When you struggle, when you're unsure, that means there's doubt. That's the definition of reasonable doubt. And unfortunately, it's not your fault. It's not the defense's fault. It's not anyone's fault but the state of Georgia, who should have investigated this case more thoroughly and brought a case that was ready to be proven beyond a reasonable doubt. And they still have an opportunity to do that. And if she is found not guilty, it doesn't have to end, because there is still someone out there who can be brought to justice. And that's what we hope. So those of you that want justice for Gary, make sure that if you're truly serious about that, look at this case. Look at everything we presented in this presentation. Go back and rewatch this trial. And I think you're going to find there is justice for Gary out there. But it may not be Melody Farris who's the one that's going to get that. Anyways, guys, I hope you enjoyed the presentation. Let me know what you think in the comments. I know there's going to still be people out there that are going to say, this is the stuff conspiracies are made of. This is not. This is what the evidence in the trial showed. Everything I took, everything I showed you in this presentation came from the trial that took place over the last 20 days. Nowhere else. Anyways, I'll see you guys on Monday, and we'll see what happens, and we'll be talking again. So appreciate everyone who watches. Hit the like button. Hit the subscribe button if you haven't. Subscribe even if you disagree. We can talk. We can debate. I have room. I want to hear from you. And until we talk again, guys, let justice prevail.